Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. So today's question is, if I have a client and this client is one of two directors of a company and a 50% shareholder of this company and the other director is the other 50% shareholder, and they've had some kind of very severe disagreement or falling out so that the company is essentially not functioning properly anymore because the directors either aren't talking to each other or something severe and negative has happened, can my client force the liquidation or voluntary administration of this company to try and resolve the deadlock and either close things up or wrap them up or part ways or do something in order to move on? So let's have a look firstly at what's called a creditor's voluntary liquidation, which is the most common sort of liquidation that the directors and shareholders of a company might put the company into. So, with a creditor's voluntary liquidation, the directors of the company have to agree to call a meeting of the members of the company, and at least 75% of the members of the company must vote in favour of putting this company into liquidation. Now, members are the same as shareholders. They're used interchangeably here. So, because the client is only a 50% shareholder and the other 50% shareholder either disagrees or is refusing to engage or who knows where they are sometimes, they might be uncontactable. This isn't something that the client can do because they don't have control of at least 75% of the shareholding. They only have 50%. So that's not an option for them. So what about a voluntary administration? A voluntary administration only requires a resolution of the board of the directors. It doesn't have to go to the shareholders. However, in most cases, a board resolution needs to be passed by the majority of directors. And if this person is one of two directors, they're not a majority on their own. There would be 50%, which in most cases is not actually counted as a majority. It needs to be greater than 50%. So what happens now? Because they seem to be in a bit of a deadlock or a bit of a stalemate because they're equally directors and they're equal shareholders. So there's this thing in the Corporations Act, which is section 461. That's the section that you or your solicitor will need to look at. And it's called a just and equitable winding up. Winding up means the same as liquidation. And there's a list of criteria in section 461 as to when it can be used to bring a winding up application, that is a liquidation application, to the court. So it will involve a solicitor's costs and the cost involved in bringing the case to the court. But it can be done. So people need to weigh up, is it worth those legal costs to bring it? And it depends on the asset status of the company, whether it's trading, the extent of the deadlock, and the extent of risk that this person is facing by being a director and being a shareholder, potentially with the company in a bit of a stalemate deadlock situation. So your answer is in section 461, and that's where you need to look to try and resolve your situation.